My name is Karra. I am a lawyer from Greece, and today I will be presenting you with a brief introduction on the private international law dimension of the smart contracts, the significance of their legal characterization, and the major difficulties in identifying the applicable law in the competent jurisdiction. Smart contracts operate through the distributed ledger technology. Three are its main characteristics, which raise questions of private international law dimension: decentralization, anonymity, and distribution. Decentralization is effectuated through the storage of the recorded data and transactions on a non-central system. Anonymity is the outcome of keeping the personal information of the involved parties unrevealed through the means of cryptography. Distribution is offered through the ability of all network participants to access all the information, data, and the transactions within the network. The lack of identifiable parties, the lack of knowledge in relation to the place of their permanent domicile, the center of their main interest, or the place of their business actually burdens the process of identifying a connecting criterion to a specific legal order, and consequently to the process of identifying the applicable law in the competent jurisdiction. But in order to determine which is the applicable law and the competent forum, one should examine the preliminary question of whether and how the transaction at stake is legally characterized in a specified legal system. This is important because it allows us to determine which conflict rule of private international law applies, and then, in a second phase, to proceed with the identification of the applicable law and the competent jurisdiction. In this video, we will be examining the so interesting case of smart contracts. The first question to examine: what is a smart contract and how does it operate? A smart contract is a piece of code or protocol that can automatically verify, execute, and enforce certain terms when specific conditions are met, following a contractual arrangement. The functioning of smart contracts is built on a conditional formula. Each smart contract involves the processing of a set of orders. The contract is finalized when it is verified that special conditions have been fulfilled. Let's take the following example. Suppose that A sells a car for X cryptocurrencies. A creates a smart contract according to which the car will be sold to anyone who will send X cryptocurrencies to A's wallet. By the time the amount is sent to the wallet, smart contract understands that the monetary condition is met and the car is automatically sold to the buyer. No third party is required for the execution of that contract. The second question to examine is whether a smart contract may be considered as a contract indeed, or whether it remains just a piece of code. Here are the most common elements that characterize a conventional contract: the existence of two or more parties, the declaration of their respective wills as depicted in the combo of offer and acceptance, and the existence of mutual consent to be bound by the agreed terms. The third and proper question, therefore, to examine is whether a smart contract may be subjected to the aforementioned criteria. To answer that question, one should commence from Nick Szabo's definition, and I quote: "A smart contract is a set of promises specified in digital form, including protocols within which the parties perform on the other premises. Evidentially, all the above criteria are met. Specifically, the element of the existence of the parties is fulfilled. The fact that the identities of the parties remain unknown should raise no question as to whether a smart contract should be legally characterized as such or not. Besides, the public address of the network participants is unique for each one of them, and therefore authenticates each member on the network, being sufficient enough to prove the existence of the parties. The declaration of their respective will is expressed through the deployment of an offer which includes a certain set of promises in digital form. Now let's go back to our previous example. Normally, party A deploys the code to the distributed ledger platform, to the Ethereum platform, for example. The deployed code constitutes the offer, which includes certain parameters as a depiction of parties A will to undertake certain promises. The deployed code constitutes the offer, which includes certain parameters as a depiction of parties A will to undertake certain promises. That is, to sell the car in return for a specific number of cryptocurrencies, and therefore to contract with another party. By the time this offer is deployed on the blockchain platform, it becomes visible to the other participant on the network. The latter have the power either to accept this offer or to overrule it. The moment the participant decides to accept parties A offer depicts the element of mutual consent. In our example, if a participant, suppose party B, decides to transfer the requested amount of cryptocurrencies to A's wallet, he or she automatically accepts the offer, and the contract is concluded and immediately executed. Party B becomes the owner of that asset. It results that smart contracts bear all elements of a conventional contract, and therefore they may be subjected to the proper conflict rule of private international law, which will indicate the applicable law in the competent jurisdiction. However, the difficulty in identifying that law and forum remains due to the lack of connecting factors as already explained. Especially in the case of smart contracts, we should distinguish between two categories: off-chain and on-chain smart contracts. And I explain myself. The risk is almost eliminated in the case of off-chain contracts, whereas the smart contract operates as a backup for a conventional contract which has been already concluded between the parties as a master agreement. In this case, the parties may have either chosen to insert a choice of law or choice of forum clause within the master agreement, or, in the absence of such a choice, traditional private international law rules suffice to resolve the matter. The real problem is detected in the event of on-chain contracts, which are totally decentralized. There, the lack of identifiable parties entails to the lack of connecting criteria to a specific legal order or forum. It has been proposed that the generated due to the nature of the technology legal gap may be filled out through the insertion of the so-called smart clauses, that is, to algorithmically embed within the code of the smart contract a choice of law or choice of forum clause. Whether this is an easy or complex task to be executed should be determined through the cooperation between the legal and the programming community. Dear all, at this point I would like to deeply thank you for watching this video. Should you have any questions or any further interest on the topic, do not hesitate to contact me directly.